Hello and welcome. My name is Zafar Iqbal, and you are watching the Mojo Story. The Chhattisgarh High Court has ruled that forced sex by a husband is not an offense as long as the wife is above 15 years old. The case involved a woman who died from internal injuries after being subjected to unnatural sex by her husband despite her dying declaration detailing the assault. The court held that a wife's consent in marriage is insignificant under current Indian law, leading to the husband's acquittal. Now, this has happened in 2017, and now he has been acquitted. The verdict clearly underscoring the legal void around marital rape in India, where forced sex in marriage is only criminalized if the wife is under 18. Uh, to discuss more on this, we're joined by Advocate Abba Singh. Welcome to Mojo Story. Ma'am, what is your first reaction after this court's ruling, the Chhattisgarh High Court, that has ruled that forced sex by a husband is not an offense, even if it involves force? How does this ruling align with India's constitutional guarantees of personal dignity and bodily autonomy of individuals?
There has been a hue and cry. Women groups and activists have been asking that marital rape should be termed as rape because in a married life, if a husband forces on himself, on his wife, then it should be a rape. But as of now, there is no law which says that a husband having physical relationship with his wife, whether yes or no, is going to be called rape. And that is what you also talked of. That is 375 of the earlier IPC exception 2, which clearly said that sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15, it was 15, but now it is 18, is not rape. So, this case also, where the Chhattisgarh High Court has acquitted a husband on whom charges were put of 376 rape, 377 unnatural sex, and subsequently, when the wife died, they had added 304, which is culpable homicide not amounting to murder. So, when it came to an appeal against the Sessions Court order where the husband was convicted of the offense, the High Court in its ruling said, number one, that, as you rightly said, that this is not rape. But the bigger issue was that the dying declaration of the wife, which was recorded by the executive magistrate, that dying declaration did not have this point. The magistrate, I don't know, that needs to be investigated. Why did he not put this fact that the wife said that there was unnatural sex and because of that she had excessive bleeding and she fell ill and she died? So this dying declaration was not fact was not given in the dying declaration. And also there are a catena of rulings of the court that dying declaration cannot be the sole basis on which you can decide a case, unless and if the court feels that it is not robust, if the court feels that it does not have full confidence in the dying declaration. Here, if you see, the prosecution number one and number two, who I believe were the parents of the victim, they turned hostile. So that is why 377 could not be proved. Now, for 375, the law is very clear, and the courts cannot go beyond the law. Even if the judge wants, even if you and I feel no, it's the
Right.
bodily autonomy and this was done, it could not be proved. So that is
Right.
why the court said that since the charges cannot be proved, and also they found the dying declaration, and in fact, it said that even for 304, culpable homicide not amounting to murder, there were no, the judges, the court which convicted him did not put it down the facts, and there was no evidence recorded in the judgment which the court could place its opinion upon. So there were grave lacunas in the investigation. The prosecution witness turned hostile, and these were the reasons that the husband was acquitted and given let free. So we cannot blame the judge. The law needs to be changed, because if till the time marital rape is not an offense, we cannot book anyone under that section.
But wife's consent is insignificant in such cases. How does this interpretation work? Doesn't it violate the basic human rights norms?
See, it does. If you talk standalone basis, if you say, of course, it violates human rights, because if a woman says is not ready for cohabitation, then her no should be taken for a no. But that cannot be considered a crime, because if a husband says that for me it was a way of showing my love, and the wife says no, I said no, what evidence do you have at that point of time? Because here also, if you see, there were not so much of corroborative evidence to substantiate the dying declaration of the wife that the husband actually committed violence on her, because the medical report said that she was suffering from piles, and that was the reason her death happened. So we may talk of bodily autonomy, we may talk of this, but then everyone is governed by the law of the land. Till the time the parliament does not declare marital rape as rape, we cannot question the judgments of courts which are based on the law of the land. While giving out a judgment, the court has to see the prevailing law, not jump its brief. So definitely, and definitely we cannot say that because the marital rape is not a rape in India, husbands transgressions would be treated as rape in a marital relationship.
But the trial court had convicted the husband, yet the High Court overturned it. You know, what legal precedent does it set for future such cases?
See, the sessions court. That is why we have a three-layered system. Even now, the state can go in appeal against the High Court order. It was a single bench. They can go to the double bench, or they can go to the Supreme Court. So there are still avenues left. But if I read the order, reading the order, you feel that the High Court judge has given a very reasoned order, because. Uh, Even for 377, the learned judge in his judgment has said that in the Navtej Singh Johar judgment, it has been clearly said that if it is consensual sex between two people of the same gender, then it should not be taken as unnatural sex. So 377 to some extent has been legalized in India. So 375, 375, 376, 377, if you go by it, it one cannot say that because of this order women are going to suffer, because every case which is decided, of course this would be a precedent, people would talk about it, but usually it is seen in every case how you present a case, what evidences you put forward, what corroborative evidence is put forward, all these things, and also the prevailing case laws. These are the things which combine with the charge sheet which is presented by the police, the evidences which are put forth. After that only decisions are taken. So one case standalone is not everything. That is what I feel.
Right. Coming to the larger question of marital rape, it remains legal in India unless the wife is under 18 years of age. But how does this exception undermine women's rights?
There is one line of thought which says that if you are going to bring marital rape, you're going to destroy the institution of marriage, because every second husband would be behind bars, number one. And secondly, for lawyers to prove that whether it was marital rape or whether it was a consensual physical relationship, it would be very difficult to prove, because within the four walls of the home, there would be no one to stand by or vouch for it what was the true fact. Keeping that aside, I mean, I'm saying that from a lawyer's perspective, that it would be very difficult to build a case on it. But there are other sections also where a woman, if she is being violated or if she is being beaten up, she can always walk out of the house. I feel Indian law is already tilting towards women. You have sections of hurt, grievous injury. So if a wife is facing domestic abuse, domestic violence, she can file a court case. If she's being bullied for dowry, she has 498A of the IPC, which is now a different section under the BNS. So what I'm trying to say, there are enough laws to protect women. And just to say because marital rape is not yet an offense in India, women are not protected, I beg to differ.
Right. And of course, there's scope of reforms, legal reforms. uh, to close the loopholes. What can be those possible legal reforms, and do you see any political will to push those reforms forward?
See, like marital rape, I don't think there is any political will to bring this law in this country right now, because nobody has worked on this. We have a National Commission for Women which can spearhead the changes. Then you have the Law Commission. People, activists, NGOs should pressurize the government or the law commission to set up a committee to study whether the time has come to make marital rape an offense. Apart from that, I feel 498A also, there are a lot of issues. After Atul Subhash, people have started speaking that it is being misused by corrupt government agencies by slapping false cases to get quick money. So I think 498A definitely some changes can be brought about, that arrest should not be made, although Supreme Court has clearly said that arrest will not be made immediately. Also, I feel uh, somewhere where we can make a change is that 498A cases should be duly investigated. Of course, the best thing that has happened is that 377 has been decriminalized. So a lot of wives who were using this section to fix their husbands, at least that relief has come forth. Also, changes I like. One thing which I feel is required, which the government must look into, even the courts, that rape in consensual sex, where people have been in a live-in relationship for 3 4 years, and then you say physical relationship under the false promise of marriage, you term it as rape, and then there are so many people who are behind bars even though it was a consensual physical relationship. That is where I feel the law needs to be changed, because it is being misused. And in fact, supreme courts have come forward and in some cases and said that if an adult woman has gone willingly into a physical relationship, then how can you say that it is rape because he promised me marriage? So that law also, from the perspective of from the men's side also, I think that law needs to be rectified. And law has to be gender neutral. We cannot have laws that are misused by either sexes, because end of the day, we want justice for everyone.
Right. But coming back to the whole point, if a woman in India wants to challenge the forced sex within the marriage, what are the legal options that are available for such a woman in currently? What are the legal options?
See, one is at times like forced sex, or if you say violence, domestic violence at home, then under the Domestic Violence Act 2000, you can move the magistrate court, and where you say that I'm facing abuse, I'm being forced upon, and I would like um, uh, uh, residence orders, or in fact, there have been under the DV, the court demarcates the household, and it makes it very clear that within 500 meters of the wife, husband will not come, whether it is a workplace or even at home. The house is divided that nobody enters each other's room. So that demarcation can be done under the Domestic Violence Act. Also, if the wife does not want to stay with the husband, she can move the court and ask for alimony or intermaintenance. She can ask for intermaintenance. She can ask for a separate house, saying that it is difficult for her to live in the same house. I mean, she can always move herself geographically. She can move out of that house, or if she's in that house, then boundaries can be drawn. This is what can be done. But beyond that, to say that if he is forcing himself, if a wife is living in the same house, because if you have a judicial separation, go for a judicial separation, because once a judicial separation happens between the husband and wife, and after that, if husband has sex with her, then it is called rape. So I think the solution is apply for a judicial separation and have a judicial separation.
Right. And you said that it is ultimately for the parliament to make a law or to change a law. But from the judicial point of view, the Supreme Court, it has been previously approached on criminalizing a marital rape, but hasn't ruled definite ruling has not been given. What are the legal roadblocks that are preventing from such a change? Leaving aside the political part of it, the making of a new law or the modification of the previous law.
See, the main thing is, what are the courts for? They are there if a law transgresses, they can declare it ultra vires. It is
Yeah,
not the job of the Supreme Court to make the law. The
yeah,
law-making power is with the legislature, the parliament. So that is the reason that people moved the Supreme Court, but the Supreme Court said, no, you cannot come to us to make a law. When
yeah.
a law is good or bad, that is our mandate, which we can look into. So this is the biggest hurdle which is there, that it is the parliament, it is the elected representatives that can make this law. And for that, I think women should be a solid vote bank. The women need to ensure that they can get their voice heard. As it is, they are 50% of the electorate, and in the last elections, everybody saw that women voted far more than the men. So I think women need to guard their interests. If they want things like this, then they need to come up as a strong voice which can be heard in the parliament. And like triple talaq was finished because the Muslim women came forward and said, no, we don't want triple talaq. So I think even for marital rape, voices have to be stronger, harder, and the parliament and the politicians should know that if they are not going to go by what women say, they are not going to vote for them. So I think that is the ultimate thing that can compel the parliament to make laws which are gender friendly, which are women friendly, or which support women.
Right. Court can interpret a law, but court cannot make a law. Thanks so much, Advocate Abba Singh, for joining us today and for sharing your thoughts. And thanks to our viewers for watching the Mojo Story.
Thank you.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.